Well, as I guess you all know, legal education, or rather the lack of it, was a principal component of the mid-19th century narrative of legal reform and thereafter. I'm going to focus really on the bar because, as you've heard in an excellent talk this morning, solicitors and attorneys had very much got their act in order long before the bar did. As the century progressed, the interest of empire increasingly featured within the domestic debates. Now, as you will all know, by 1895, the empire encompassed a quarter of the globe's surface area. And another statement of the obvious, if I may, and it may not come as a complete shock to you, the principal imperatives for the survival of this vast source of wealth and power were obviously the maintenance of territorial security and also an attempt at loyalty in the indigenous population to an empire and a distant empress. Just going to move my computer a bit so you can see more of my ugly face. Now, one might have thought for the Imperial Vision to work and to be respected by the indigenous populations from whom loyalty was demanded, that it might have required proper training of the very people who were entrusted to dispense civil and criminal justice to 1/5 of the world's population, these being the imported judiciary, often drawn directly from the English bar, district commissioners, resident magistrates, and so on. You might have thought that, but that wasn't the thinking of the legal establishment, and certainly not that of the Inns of Court. Until very late in the century, the Inns had resolutely resisted any and all external interference in their affairs. They willfully, consistently, and it has to be said, successfully obstructed all attempts at systematic education and quality control for England and Wales, let alone the Empire. Now, this is a vast topic, and what follows in this talk is very much a broad brush approach, so I apologize now for probably a great deal of oversimplification. Now, as I understood it, since the mid-18th century, Oxford and Cambridge did in fact have chairs in jurisprudence and what was known as civil law, which was a strange mix of Roman law and some elements of the common law. These were residual by the time we're speaking of, and by mid-19th century, both schools were recognised to be moribund and ill-attended. It's been said that the Cambridge Law School, for example, and I quote, was generally recognised to be a refuge for those who were averse to intellectual effort. And the institutions of the bar, notably the Inns, also preferred to believe that these law schools were irrelevant. A non-legal classics degree was sufficient to furnish a student who intended to enter legal practice with what was infinitely more important, gentlemanly habits and a civilized outlook. So until the 1870s, the formal qualifications for legal practice, and more importantly, legal office, simply consisted of having an Oxbridge degree, not usually in law. And I think London degrees were permissible later on in the century, followed by an optional period of reading in chambers, pardon me, and obligatory dining in hall for a requisite number of terms. Now, I did my dining in the 70s. That's the 1970s, not the 1870s, but I'd be interested to know if somebody does, if dining is still a requirement. I can remember from my days, they were basically drunken fests. And I will allow myself, if I may, one anecdote to give you the flavour from the last century. A colleague and I were leaving Gray's Inn and walking down the steps, and there was a very drunk young man. Obviously, he'd done the whole course of sherry, wine and port, with his head resting on his umbrella. And my friend said to me, "Look at that minor public school twit." And the chap looked up and he waved his umbrella and he said, "Not so much of the minor." So that was, I hope things have changed, but I suspect they perhaps haven't. Dinners were followed by an optional period of reading in chambers, pardon me, obligatory dining and yes, I've done that bit. Crucially, and unlike all other professions, including, as you've heard, solicitors, that meant no examinations and no quality control. Particularly within the empire, it was instead patronage rather than qualification, which was the principal route both to securing a practice and to public appointment. Thus, the popular newspaper, The Globe, wrote in 1846, quote, "We know that how many persons eat their way to their call for no other purpose but to qualify themselves for some office, which good connection and patronage may procure. Such men have perhaps never read a single book in the law, or been for an hour in the chambers of a pleader, and the present system of calling to the bar enables them to become judges, Queen's advocates, commissioners, registrars, with large salaries, both at home and in the colonies." And that's just one example of what in fact was a torrent of criticism in the press throughout the 19th century about the paucity of legal education. And the efforts of domestic reformers were energetic from the 1840s onward. For example, they engineered, and I think it's fair to say when you look at the composition, that they packed the Parliamentary Committee on Legal Education in 1846, and then a Royal Commission in 1855, both of which produced swingeing reports, and both of which came to nothing. Passing judgment on the skills of bar students after the report of the 1855 Commission, the Whig Weekly, the Cambridge Independent Press, for example, suggested that an examination in spelling might be an appropriate addition to the Commission's recommendations. The principal reason why these two powerful and frankly irresistible reports achieved nothing is that they were thwarted by the ends and the diffidence of successive governments, perennially populated by senior barristers and law officers. We should, I suppose, pause to acknowledge that between the two, the committee and the commission, the Council for Legal Education was set up to provide some lectures, but this was, I think it's acknowledged to have been just a sop to public opinion. The CLE in those days was largely ineffectual and poorly attended, as aspiring barristers simply saw no point in submitting themselves to occasional lectures, which was all that was provided, as that contributed nothing at all to the process of admission to an inn or call to the bar. So why bother? And indeed, when voluntary examinations came in a little later, same attitude. If they were voluntary and they didn't contribute to qualification, why bother? The 1870 conservative Pall Mall Gazette referred to these voluntary exams from the CLE as, I quote, "a somewhat torpid system of readerships and examinations now existing under the auspices of the Council of Legal Education." And it noted the increasing public attention to the want of an organised system of legal education, which included our colonies, which are beginning to discover that the credentials furnished by a call to the bar at home are worthless as a guarantee for either legal knowledge or competence for business. Bear with me. I'm conscious that I'm shouting. I think this is possibly a hangover from professional habits. Other papers, such as the Examiner, in the same year were more barbed. Quote, "One of the most amusing of legal fictions is that everybody knows the law. Nothing, as a matter of fact, could be less true, for it would be hard to find a lawyer who could conscientiously affirm that fiction of himself. The standard of general education required by the inns is simply absurd. To attend and hear lectures is thought to be a heavy enough penance, and candidates are mercifully spared the torture of an examination on what they've heard. A later edition of the paper queried whether the inns, with their, quote, with their immense wealth, should be content to let into their ranks men whose training consists in their well-demonstrated capacity for eating and drinking. I take that to mean well-demonstrated because they got drunk. The journal adverted both to the needs of empire and to those of competent, domestic judiciary. Such men are sent out to the colonies entirely ignorant of the most elementary distinctions between actions. So it wasn't really good, really, was it? Quality control in the shape of compulsory bar exams was fiercely resisted until 1872, when after a prolonged battle which had been waged for over 30 years, the inns agreed to make Council of Legal Education exams compulsory. Frankly, because if they didn't, they knew that by then there was such a groundswell of public opinion. So that legislative interference was possibly an inevitability. In the second half of the century, successive reformers like Randall Palmer, of whom we've heard later, Lord Selborne, took the fight to Parliament. And it's interesting to note that reformers were acutely aware of the negative consequences for imperial interests. In a debate in 1871, Palmer developed a theme which was becoming more obvious as the century progressed. And I quote what he said in the parliamentary debate: "We must remember that we are the centre from which radiates law to other great regions of the earth. In the colonies and in the East Indies, we undertake the administration of law, and we send out a continual supply of judges and barristers to carry on the traditions, the knowledge and practice of our law in those remote possessions. Is it not of the greatest importance that we should do our best to ensure the proper qualification of those that we send?" I'm just checking on my timing here. I think I'm all right, am I not?
You've just got a couple of minutes.
Okay, I'll speed up. Sorry about that. Got carried away. The training of Indigenous lawyers. Sorry, I'm reading ahead. I think we need to trouble with that. The Empire's grand civilizing mission, and one of the main advocates of that being Macaulay, the Whig historian, a member of the Supreme Council of India. And he said in a speech in 1833, so quite early, "I feel that for the good of India itself, the admission of natives to high office must be effected by slow degrees, but that when the fullness of time has come, when the interest of India requires the change, we shouldn't refuse to make that change, lest we should endanger our power." And those are the key words. This was not remotely, however, a benign objective. The intent through the medium of the English Education Act, which he sponsored, was to withdraw government funds which had previously been applied to traditional Muslim and Hindu education. Henceforward, that money was to go to support establishments teaching a Western curriculum with English as the language of instruction. As Macaulay put it, and I'll finish up with this, English is better worth knowing than Sanskrit or Arabic. The natives are desirous to be taught English. They're not desirous to be taught Sanskrit or Arabic. It's possible to make natives of this country thoroughly good English scholars, and to this end our efforts ought to be directed. He said, "It's no exaggeration to say that all the historical information which has been collected from all the books written in the Sanskrit language is less valuable than what may be found in the most paltry abridgments used at prep schools in England." So you get there, as always, a profound element of cynicism in what might have appeared at first blush to have been a positive reform. I think I will draw it to a close there. Thank you very much.